This is Colin O'Keefe here for LXBN TV. The Ninth Circuit Court of Appeals recently upheld an actress's copyright infringement claim against Google for its failure to remove the highly controversial Innocence of Muslims film from YouTube at her request. Joining me now from Boston to explain the suit and its potentially very large ramifications is attorney Nicholas O'Donnell. He is a partner with Sullivan Worcester and author on the firm's blog, The Art Law Report. Nick, first, can you explain the basics of this suit? What exactly happened here?
Sure. So as viewers may recall, Innocence of Muslims was a video that came out about 2 years ago to much notoriety. It portrayed the life of the Prophet Muhammad in a very disrespectful way, and it engendered a huge amount of protest, some of it violent, including at the U.S. Embassy in Benghazi. And what it also engendered was that many of the actors involved immediately spoke up and said that they had no idea what they were participating in at the time they filmed a movie that they thought was going to be something else. Shortly after all this brewed up, a woman named Cindy Lee Garcia filed a lawsuit in district court in California alleging that her acting performance was entitled to its own independent copyright, and that therefore the distribution of this movie, the continued distribution and availability on YouTube, infringed her copyright. The U.S. District Court, in ruling on her preliminary injunction request, which requires a consideration both of the merits of the case and the relative harm to the parties, concluded with very little difficulty that she was not going to prevail because motion pictures are either joint works, which this was not, because she claimed no authorship in the script or the topic, and indeed disclaimed knowing anything about the ultimate product, or they are what are called works for hire, which is a circumstance in which the creator pays employees to do something. They do it, but the creator is the one who retains the ultimate copyright, and that is how movies work because, as we'll get to in a second, it's essentially the only workable way to do this. The Ninth Circuit Court of Appeals, a few weeks ago, reversed the district court's ruling, concluding that this did state a viable claim for an independently copyrightable performance, and then proceeding to the rest of the analysis that the relative harm to her was greater because she had received death threats, and the stakes seemed to be very high for her.
I see, and then the second part of this is what's the impact? I know you wrote at the time that this could potentially be very big, but there have been some developments since then. So what exactly does this mean for the film industry?
So the reason this is potentially so far-reaching is something I alluded to very briefly a moment ago, which is a motion picture is necessarily a project involving hundreds or thousands of people. And there is a screenwriter in the first instance, there are producers, there are studios, but someone has to be the quarterback of the project. Someone has to be the creative driving force. And there can be disagreements as to whether that's one or several people. But typically, and by written contract, actors will agree that they are performing a work for hire, which is a separate statutory provision of the Copyright Act. And it clears up any confusion. If one of my employees writes something for me, and then I make a Sullivan Worcester publication, Sullivan Worcester owns the copyright, not me, not the employee. This is essentially a case of first impression because the argument was regarded as novel at best when she made it a couple years ago. The complexity may have come out of the fact that this was clearly a slipshod operation and there were no written contracts or anything else, but those are not required. The problem is, while many studios undoubtedly have good documentation and best practices as far as agreements with their actors and employees, they don't necessarily. And the prospect of any actor in any film claiming that her performance was so original and creative and fixed in the medium of the movie itself that they have a right to control its distribution would conceivably bring the movie industry to a halt, taken to its logical extension, which could be a very big deal.
Absolutely. It's going to be interesting to see if this claim does hold up because, as you mentioned, if this is extrapolated out across the entire film industry, the impact could be very, very large. Once again, that was Nicholas O'Donnell of Sullivan Worcester. For more of his insight on this case and other happenings in the world of art law, be sure to visit theartlawreport.com. Thank you for joining me today, Nick.
Thanks very much.